Federal High Court in Abuja on Tuesday dismissed a suit filed by 5 persons who identified themselves as residents of the Federal Capital Territory to hold the inauguration of Bola Tinubu as president. They sought the court to stop the Chief Justice of Nigeria, Justice Olukayode Ariwola, any other judicial officer and/or any other authority or person from swearing in any candidate in the February 25 presidential election as president or vice president of the Federal Republic of Nigeria. The suit demanded in part a declaration that no state of the country is at the same time the FCT for any purpose whatsoever, including in particular under Section 134 subsection 2b of the Constitution. Plus, they also wanted a declaration that no candidate in the February 25 presidential election in the country may validly be declared elected president of the Federal Republic of Nigeria without that candidate obtaining at least 25% of the votes cast in the FCT Abuja. In summary, their prayers, if heard, would have invalidated the declaration of Bola Tinubu as president. Not only that, it would have also nullified any process or processes taken to swear him in as president. Now, joining us virtually is Barrister Eze Eluche. Barrister, good morning and welcome to VOP this morning.
Well, regarding the court judgment which was delivered yesterday, the issue was not really even the 25%. The issue was the court deemed it that the litigants did not have locus standing to approach the court over this issue. And I think that is most unfortunate. Why do I say it's most unfortunate? Way back in 2007, in the celebrated case of Gani Fahemi against Akilu and Halidu, the Supreme Court had ruled that for a Nigerian, all it takes for a Nigerian to have locus is for you to show that your rights will be vitiated or will be impaired in any suit. And this, the issue of the presidency of the country, it shows that the people who are the litigants have a valid right to sue, to approach the court. But the court held that these people, the litigants, did not have locus standing. And we have had that language repeated in several of the actions which were filed to address constitutional matters, be it 25% or be it the issue of the drug issue. The court keeps on referring to the issue of locus standing. Every Nigerian has a locus standard to challenge issues that relate to how he is governed. So why the courts are now taking us backwards, it gets the imagination. Not only do the courts take us backwards, the court goes further to unleash very punitive costs, award costs against the litigants. 10 million, in fact, in the last case was 20 million against the lawyer who filed this action. Now, what is the court trying to tell Nigerians? Is the court trying to tell Nigerians that we don't have a right to approach the court to address issues?
But Barrister, the presiding judge said that the suit can only be filed at the Presidential Election Petition Tribunal and not the Federal High Court. Could that be the reason why that fine was, meted out on them?
That what the litigants asked for in this case is different from what is being asked for at the Presidential Tribunal. If you recollect, in the Presidential Tribunal, Election Tribunal, none of the parties, whether Labour Party or PDP, asked for the inauguration to be stopped. None of them. But in this case, the litigant is saying that there should be no inauguration, and any inauguration that has been done should be deemed to be invalid. So on that premise, the litigants are asking for something different. I mean, what should worry Nigerians is if the court keeps on saying we don't have locus, then what does the court, is it trying to diminish the under Section 36 or 39 for freedom of expression? If the court says we don't have locus, what of public interest litigations? So carried out by this civil rights group, SERAP. SERAP gets into matters, challenges the federal government on tax issues, on shipping issues, on election issues, on economic matters. And the courts keep on hearing those matters. No court has dared to say SERAP does not have locus standing on issues that concern the generality of the population. So why will the court now go ahead and say, but the litigants who have proved that they're Nigerian citizens, that they voted, that they have voters' cards, and that they feel disenfranchised, or that they feel that the wrong person was imposed upon them, the courts are now saying that they don't have locus. And these courts are inferior courts to the Supreme Court. The matter I mentioned, both in the Adesanya case and in the Gani Fahemi case, The Supreme Court, after fully interpreting the Constitution, ruled that Nigerians, all they have to establish is that their rights or their rights, their civil rights will be infringed upon. And once you prove that your civil rights can be infringed upon, you have law. So will you say that the imposition of a Bola Tinubu has not infringed on the civil rights of those Nigerians who are saying they shouldn't have been sworn in? I mean, the danger of this is that the Gani Fahimi case and the Abraham Adesanya case, 2007, took place under despotic administrations, under military regime. So if under military regimes they had these locals, for goodness sake, why will it now be under civilian regimes that Nigerians will be deprived of their locals standard to approach courts?
But Barrister Ezra, the plaintiffs also wanted a declaration extending former President Muhammadu Buhari's tenure, considering that they felt Bola Ahmed Tinubu should not be inaugurated on May 29. Is that a good possibility to take place? Do you think that's also one area whereby they found some porosities in their petition, to the Federal High Court? Because, and again, considering, is it in the Constitution to allow that vacuum for an extension of a president who's meant to leave the office for a period of time pending when the incoming president's situation will be resolved?
Now, you have to first of all overcome the issue of local standing to get into this nitty-gritty of the case. The court did not even bother to venture into that area. I myself may not agree with all their demands, but I agree with their right that they have locals to approach courts to interpret the Constitution, to determine civil issues and civil rights. So the court did not even go that far. The court blocked the litigants severally from even approaching the court by saying they don't have locals. With regards to whether the issue of elongating or giving more days to the regime of Muhammadu Buhari, the fact is that constitutionally, that regime ended, the tenure of that government ended on May 29. Well, however, with a court order, once it's a valid court order given, anything is possible. If the court, in its wisdom, determines that it is proper to allow the Muhammadu Buhari government to extend a day or a month or 6 months beyond May 29, it is the judgment of the court. That becomes an issue that will be discussed or that can be challenged upon appeal. The worrisome part of it is that the court claimed that Nigerian citizens who are voters do not have a right to come before the court. If a Nigerian does not have the right to come before the court to challenge to have the Constitution interpreted, if a Nigerian does not have the right to come before the court to have his rights protected, for goodness sake, what are the courts for?
All right,
the courts.
Barrister Izzy, I might need you to help me to throw more light on the Electoral Act 2022 as it relates to this case now. And I'm going to take an excerpt from what Justice Ekwal said in delivering judgment on the case. I'm going to quote him as saying that he said, "On the whole, I find that this action is premised on recklessness, frivolity, and complete lack of knowledge of the elementary principle of law as it relates to the Constitution and the Electoral Act 2022. Please help me understand how this relates to recklessness on the part of the lawyer who filed for this."
Well, I mean, from the language of the court, you can see there is evident bias. The court was now trying to squash the fly with a sledgehammer, having ruled that the litigants don't have local standing. It was now like gathering using whatever language it can to vilify the litigants, vilify the counsel and the litigants in this case, because the language was beyond what should have been used in this case. What does the court mean by recklessness? A matter was filed before the inauguration. The matter addresses very vital issues of law and constitution. The issue of whether 25% in Abuja is a constitutional requirement. What is reckless about that? It is pure facts. If the court did not want to go into the matter, there was no need for the court to show evident bias by going further to begin to abuse the litigants And it went far beyond what we have expected of the judge in this instance. If he had stopped at, okay, you don't have locus, yes, you can say, okay, you finished. That is it. Let somebody else do the job. You didn't go into the matter, and how did you know about recklessness? How did you know about all these issues? You cannot determine recklessness without hearing the or the evidence of the parties.
All right,
and I have had opportunity.
Go ahead, please.
What they filed, yes. What they filed was not reckless. What they filed is very, very clear. And it's even now coming up even before the tribunal. We can see that in one of the evidence of the PDP candidates, the issue of this 25% in Abuja came up. So the court should not have declared it, said it was reckless. It is not reckless, and that language by the court was very unfortunate. And I believe that if the litigants, the plaintiffs in this case, will go on appeal, I'm sure the bench will be able to address the issues that the court, in my own opinion, attached so much bias and vehemence in trying to squash.
Okay, so now what part of the Constitution talks about the 25% votes for Abuja? Can you tell us more about it?
No, it is section one of the section 137 that of the Constitution. I mean, I don't have it on me now, but it says that to be qualified to be elected as president, a candidate must have 25% in 2/3 of the states of the federation and 25% in Abuja. Now, what it means is very clear. I mean, we ridicule ourselves before the international community when we keep on making discussions over very ordinary issues. The law is very clear. It says to win an election, for this election, you must have 25% of the votes cast in 2/3 of the states of the federation and 25% in Abuja. Now, 2/3 of the states of Nigeria is 24 states. 2/3 is 24 states. And Abuja. Now, let me give you a very clear example. If you're going to apply for JAMB to get into a university, and the criteria for getting in is that you must have 5 credits and English. 5 credits and English. If you have 10 credits and you don't have English, are you qualified for that admission? The blatant answer is no. Let us stop going around as if we are high on some substance. The issues are very, very clear. Perhaps the error is that they forgot or they neglected to add 25 to manipulate figures and get to also have 25%. But this is not an issue that should be discussed in any reasonable community. The Constitution is very, very clear.
You use the word manipulated. It precisely in what term? I need you to explain that particular word you use.
No, I mean, when I use it very clearly, in Lagos State, the PDP and other parties said it was the Labour Party that won. And in Rivers State, it was very clear, even from the INEC, it was the Labour Party that won. And still, in these 2 states, amongst other states, INEC was able to manipulate the figures and read out rubbish that ruled that it was not this party that their figures. So maybe the language is a bit harsh, but I'm trying to be very, very factual. Okay, I withdraw that language. This is on national TV. But in those two states, for goodness sake, in those 2 states, I'm just using that as an example. There was clear, evident manipulation of figures, because even what INEC posted on their IREF, on the IREF portal, differs from what was announced by the INEC chairman Yakubu at the Election Collection Center. So that means simply there was manipulation. I mean, you don't have to mix figures. We have to, at times in this country, we have to be very factual with each other. We have to be very truthful and say things as they are, because posterity will befall us, is before us, and will judge us if we don't say things
as they are. All right, now let's look at this now. The outgoing Senate of the 9th Assembly yesterday granted the president request to appoint 20 special advisors. And this was amidst a nationwide crusade for prudence in the management of the nation's resources, the resources that are scanty, if you ask me, and also to cut down on governance. Now we're having 20. The the president sent a letter to the Senate which did not disclose the identity of the proposed advisors. Now the letter was read by the Senate president on the floor and hurriedly approved as well. There was some sort of urgency to it. And the letter carried a request for only special advisors, leaving the possibility that the president may later appoint more individuals as special assistants, senior special assistants, and others into the presidential aid portfolio. Now, we have a section, section 151, subsection 1 of the Constitution, which permits the president to appoint any person as special advisor to assist him in the performance of his duty as president. Subsection 2 of the same section 151 empowers the National Assembly to determine the number of advisors and their remuneration. Now, the president, in his request, did not reveal the identity of those advisors. That is source for concern for a Nigerian like myself. And I'm asking, is he thinking on the go? Is he just going to, okay, look, just approve first, and then when I go back, I look at who and who I should put in what? Now, we also know that the president rose to power, from a series of political deals and consolidations, and could this be seen as an intention to pay back, those that helped him get to power? What do you make of that?
Well, let me start from the very last angle of your question. Is it an intention to pay back? Obviously, of course, there will be payback. I mean, that is how politics works. There will be payback for those who supported or worked for him. And we only hope that he will be altruistic. He will think of the interest of the country first, and not just appoint people because they were lackeys or they helped him get into office. But what we should find more worrisome is the language of the letter that was read before the Senate, that was addressed to the Senate. Mr. President said that he asked for 20 advisors who will help him to run the country, pending when ministers will be appointed. If we look at his immediate predecessor, Muhammadu Buhari, that one took us 6 of running a country without direction before he appointed his ministers. We only hope that Mr. Tinubu will not go that direction. And one would have thought that with his refrain of Milokon, that I am the next, it is my turn, one would have thought that he will hit the ground running and not begin to beg for time to appoint ministers. It shows that perhaps it was only his turn to grab power. It was not his turn to govern, to do the real work of governance and administering a policy like Nigeria, because one would have expected that by now he would have actually reeled out the name of his ministers, and so we can begin to appreciate the direction of his government. With regards to the number 20, look at the convoy of Mr. President. I mean, you are going in the 50, 60 car convoy. You brought state of the art limos. Nothing is wrong with the one used by the former president, and you have now acquired brand new limos. That is not how it is in a serious country. In the United States, for instance, the US president has a vehicle which is called the Beast, which is a state-of-the-art limo. Mm-hmm. And when you are leaving office, you don't carry the Beast along with you. There was no need for Mr. Buhari to have taken away all those flashy cars that was bought with taxpayers' money as he was going. He should have left that in those bulletproof vehicles. He should have been left for Mr. Tinubu to continue using. And when you now see those in office wasting funds in such manner, and they are telling you and I that we should tighten our belt, that we should we cannot be riding bicycles and trekking while the person who is supposed to be serving us is busy spending billions, wasting billions on buying vehicles. And now he has mentioned 20 advisors to start with. I wouldn't be surprised if, like some of the governors were doing, he has up to 360 or 1,000 advisors, because this kind of rubber stamps National Assembly will approve whatever. And you saw it in this time around. Within a few hours, immediately it was read, it was approved. They didn't ask this question. Any genuine Nigerian patriot will ask, who are you appointing? Can we see their CVs? Can we know who they are? They approve. This is how the Senate has approved. Before they have approved the way Nigerians sovereign wealth. They keep on approving all manners of junk, including the ones that were approved in the last 2-3 weeks of this of the immediate past regime. They approved unconscionable judgment debts. They are over, in fact, we are trying to calculate the figures, over 700 billion naira. They approved $800 million for $800 million for palliatives. They approved over 2 trillion for funny names. So I'm not surprised that they are approving. Even if the president brings up a request for the devil to come and rule Nigeria, this Senate will approve it. It's unfortunate. We are stuck with them. But we can't wait for them to go, and let's see what happens with the next, with the 10th National Assembly. But the current National Assembly has been an unmitigated disaster. They have been a minus to democracy, and they have been, in fact, they have retrogressed Nigeria by decades.
Okay, now let's look at this now. We know that the president, with the announcement of the removal of the subsidy on fuel and the call for strike that was later quashed, there's been a lot around him now. Well, in comparison, if you want to look at this president to the previous one, we know that the president is on ground. He's having talks. He's doing things to show that, yes, he's aware of what is going on. Could it be that the advisors he's seeking for, I mean, I'm trying to understand the urgency with which the Senate had to pass this, regardless of the fact that names were not on the list. And one would wonder, how long does the process usually take? Okay. You know, we've learned that it usually would take between 2 to 3 weeks to peruse and investigate the persons that would be advisors before approval. I mean, a committee is supposed to look at them and then send approval to the House before the House will now go ahead and, approve the list. But now, with the president of the Senate saying, oh, there's an urgency, we need Mr. President to have his advisors and work, let's just stamp this and let's just go ahead and, one wonders, what is playing out here? Is it that the president feels overwhelmed by what is going on and just needs advisors to come on board, and these advisors would be paid, obviously? Or is it that, please help me understand this.
Perspective. What normally takes that long to approve are the list of ministers, okay, and maybe chairmen of boards and commissions. That's usually what requires committee hearings and appearance before the Senate committees or the Senate in plenary. Usually, the issue of advisors are one of those things that the Senate over time have allowed the person occupying the office of president to do what qualifications they need, and in most times we have seen
it's left at the discretion of the president. There's no necessary having to go through requirements or having to go through any perusal. The president can choose any person he wants to be as part of his special advisory team.
Yes, that is a fact. The president can choose whoever he wants, but the law is that the National Assembly has to put a number. I mean, that he can appoint, so that he doesn't go ahead and appoint 100 or 200. But the National Assembly has not gone that extent, has not fixed a number yet, and it will not even be in their purview to even fix it, because in the next 1 week, there will be a new National Assembly coming on board. So what they've done per se is not inherently unlawful. It is, okay, the president cannot be expected to do all the decision making himself. He needs to have advisors, and then they have to be paid. The last regime, Muhammadu Buhari, one of his closest advisors was his nephew, and he has a lot of relatives around, some of them without portfolios, who were salaries as advisors. So we were hoping that under this new dispensation, realizing that the country is in a deep economic quagmire, there would have been more prudence, and then there will be more tact applied in deciding on the number of advisors and who actually. From past experience, Nigerian presidents have chosen their advisors at their own discretion, but the National Assembly has a duty to peg the number of advisors and the number of the amount, emolument, their remuneration, which can be done by the revenue mobilization commissions. So nothing wrong has been done yet, except the haste with which it's been done. That is problematic.
All right then.
All right, thank you so much, Barrister Eze Oluche, for being part of the conversation this morning. We do appreciate your time. All right, I think up next we'll have business and entertainment.
Thank you very much.